You're listening to Members of the Jury, the show that takes you straight into the trenches of justice, where the passion, players, and consequences are real. Each episode, we examine current events happening in the system. From the battles in courtrooms to the streets demanding reform, we bring those stories here to you, the members of the jury, because we aren't afraid to take it to the box.
What's up, members of the jury? Happy Freedom Friday. Thank you so much for tuning in. I'm so glad that you are checking out another episode. And today we have a fantastic jury trial breakdown from one of my brothers in arms, a fellow public defender within the state of California. Fortunately for our residents of California, me and him are in different counties, and so we're able to tackle the injustices that are happening throughout our state in different area codes, but ultimately fighting the same fight. It's pretty surreal to actually be sitting here having this conversation, because actually not that long ago, my guest was actually an intern with my office before moving away and passing the bar and becoming his own attorney. And so the way that the world works is incredible, and I'm so excited to hear about how he's hit the ground running. He's hopefully taken some of the lessons that he learned through his internship and applied them to his skill set. And it sounds like he did, because he's here as a guest on our show to give us an amazing result. I'm super excited to get into it. I know there's a lot of nuances to this case, and we're really excited to hear about how he was able to obtain such a fantastic result. So joining me today is Deputy Public Defender Luke. Luke, please introduce yourself to the members of the jury.
Hello, members of the jury. My name is Luke. I'm a deputy public defender in Los Angeles County. The trial that we're about to talk about happened at the Metropolitan Courthouse in downtown LA.
And that's the crazy thing that I know about the LA system, is that it's probably one of the biggest counties in the country with the number of courthouses that it have and the ways that it operates. So I'm really thankful, Luke, that you're taking the time to join us to give us a trial breakdown, even while you're in the midst of doing another jury trial. So just thank you so much. Thank you so much for joining us. We're really excited to get into it.
Thank you for having me.
Why don't you give us an insight, start us off from kind of like the beginning grounds of the case. Why don't you let us know what the charges were, and ultimately what were kind of the motivating factors that led this case to trial? Was it just negotiation breakdowns, or really that proclaim of innocence and principle stance that your client was taking?
The charge in this case was driving under the influence of alcohol. It was the A count only, so they did not have numbers in this case. They weren't alleging that he was above 0.08. They were just alleging that he was impaired to the point where he could not drive. And then they charged him with 148, which is resisting arrest or delaying an investigation. The prosecution theory of what happened in this case is that my client had, they didn't dispute this, alerted the police, called 911 about an intoxicated minor who he said was being harassed at a party. He flagged down a patrol car. And their narrative of it is that he started tailgating the car. He started yelling profanities at the police officers, egging them on, that they got out of the car to defuse the situation, that he essentially got aggressive with them, and that they restrained him, and they said that he pulled his car in front of their car, blocking their car from moving forward, thus delaying the investigation that he called the investigation for. And then they said that he physically resisted while he was being arrested. And then they said they smelled alcohol on him, that he was belligerent, acting intoxicated. And that is the basis of the three blocks he drove was the basis of the DUI. So that was their theory of the case.
Right off the bat, you got to love that the case starts off with your client calling the police, end up being arrested and being charged. I love you got to love the system. Like, how even if that is the case, like we see it time and time again, where especially it seems to be like our type of clientele who call the police to, have a legitimate complaint, but then when the police show up, they immediately get sidetracked from the underlying complaint and want to direct their attention to things that, might not necessarily be at issue and then blow it up and here where we're at. So what a super interesting facts right off the case. So they ended up charging your client. We'll get into the aspect of the trial with the charges, but did they ultimately follow up with his underlying reason why he called the police, or once they kind of set focus on him, everything else went out the window?
That's a great question, and it was a focus point of the trial, and they actually called a witness to say that they did not find any minor being harassed, but that's their version turned out to be completely ridiculous, and we debunked their debunking of his claim on cross pretty effectively. So I'll save that for the trial. But yes, they did eventually respond to the house, maybe about 2 hours later.
Understood. Okay, yeah. So definitely gave your client the main focus of their attention when they arrived on scene, which is, I would say, uncommon when you read police reports and you see them addressing. They definitely go to the reporting party first, but very seldomly does that then turn into its own investigation. So, yeah, let's get into the trial. As always, we start off with motions in limine. In this case, were there any evidentiary issues that you had to litigate during the motions in limine process that you thought would be impactful during the trial phase?
Yes, and this actually does tie in with why we went to trial to begin with. My client, from the first time I met him, said, "Look, I am 100% innocent of what they're accusing me of. This is not how it happened at all." So we knew that he was going to have to testify. But my guy, he's been involved in the system. Had recently spent 2 years in county jail, and so I knew I needed to exclude his criminal history. And so that was. I think there were a few others, but that was a main one because I knew that it was going to look less than ideal if he had either previous. I think there might have even been a previous 148, but he went to 2 years in county jail on a burglary charge. And just a quick side note too, I just want to say what the offer in this case was, because you asked why it went to trial. The offer in this case was for him to plead to DUI, 15 days of community labor, which is like or county jail. So in LA County, community labor is like Caltrans. It's hard manual labor that you were unpaid for. They wanted anger management classes because of the 148. And I told them this is a completely ridiculous offer. This is not what the case is worth. And the person who was the way it worked in the Metropolitan Courthouse is when you set a case for trial, it went to a master trial calendar courtroom, and the lady there would deal with the offers. And she sort of just scoffed at me and said, "Well, we see this case very differently." Okay, all right. So we got sent out.
That's always this seems the case. It boggles my mind that I feel like prosecutors really never see cases that they issue as triable cases. It's always like, why is this going? And it's like, obviously we have reasons why it's going to go. Like, we're not just going to waste everybody's time if there weren't triable issues. So that good for you for, especially at what I would imagine being, a lot of times prosecutors put more experienced prosecutors in positions to negotiate. And I think a lot of times they try to maybe utilize that experience on younger attorneys to leverage that or strong arm us into not going forward when we feel that we have a righteous case. And so kudos to you for overcoming that difficulties. I know you had mentioned that there was maybe a prior 148. Were there any prior DUIs that you were worried about coming in? Because we know obviously priors of similar charges are really the ones that we're trying to exclude.
No, he did not have a drinking problem. He was like many of us, a social drinker, but no issues with DUIs before. He laughed at the idea that he would ever drive under the influence of alcohol.
Got it. And so how did the ruling go with regards to your request to exclude his criminal history?
Well, the judge I was before, this was actually my second trial in front of him, and I previously had a degree of success in his courtroom. So he already liked me and respected me. He was a former prosecutor, but a very even-handed judge. And he very much wanted to kind of hear how things played out before deciding if it was relevant or not to admit it. And it was pretty obvious as the trial played out that he thought that my guy should walk. And I think that influenced his ruling. And he really thought that, I think he understood that it was important that he testify. And in terms of, the biggest factor for him was he thought that it would discourage my client from testifying. And so he said none of it's coming in, and the prosecutor was shocked. And then the next day asked the judge to reconsider his ruling, and he said, I think I was pretty clear the first time.
That's amazing. And that's good for you too, because a lot of those times I feel like on those type of motions in limine, the judge likes to reserve, like you indicated, to see how some of the evidence plays out. And so as you're moving throughout the trial, you still don't really know which way the judge is going to rule. So to be able to give you that type of affirmative response before the trial even started is definitely a kudos to you, because that's a huge win.
Yeah, well, he was going to always testify no matter what, but it certainly made it easier.
Well, that's awesome. So is that pretty much the main motions in limine that you had, or were there any others that kind of were points of contention?
There was one other one now that I think about it. So he had made various references to having been convicted of crimes before in the past when he was talking to the police, basically making comments like, look, like, you know, I've been arrested before. Like, you think I would want to just call the cops for no reason? He made comments like that, which, you know, I thought if for some reason that didn't come out, that it could actually go to our benefit to say, look, like, this guy is not just calling the police willy-nilly. He had a real concern. But I still, at the end of the day, did not want the comments about him previously being on probation and having criminal past. He also, my guy was he was a Latino guy, and did use some racial epithets as he was rambling. Neither of the officers were African American, but it didn't look great, and so I also did a motion in limine for that to not be mentioned, and that went our way as well.
Oh, good. And that's what I was just about to ask you, you know, like as you were, and we're about to get into kind of the opening statements, but like as you were approaching the opening statements, I guess, what were some of the initial thoughts that were going through your head? Because I mean, I mean, obviously you have to view this from multiple lenses, right? And I'm sure that you have your facts and you have your elements, but I mean, DUI and 148 is just kind of societal. Like in society, we know that those two offenses have such negative connotations because jurors hate DUIs, and depending on your county and the type of jury pool, they could be super cop loving and pro cops. And so then hearing you're having a crime against either delaying or even potentially injuring a cop, you know, even if the facts are on your side, you have to deal with the emotional stigma that comes across with those charges. What was your mindset with that component as you were going into your opening statement?
You know, I have a different approach than a lot of defense attorneys. I know a lot of people like to keep their opening statements. They kind of like to keep their cards to their chest. For me, it's the one time that you get to talk to the jury without anybody being able to directly respond to you. So I put all my cards on the table, unless there's one that I really have to hold on to for some reason, something that might be for impeachment. So before this case went to trial, I reviewed all the body worn. There was quite a bit. And it was just so obvious that the police report was a complete different version of events than what actually happened. And it wasn't just based off what my client told me. I mean, my client gave me his version of events, and it was completely corroborated by the body worn. And so I just laid it out to the jury. I was like, look, this officer is going to testify this. What you're going to see is this, and I told them exactly how it was going to play out. And I think that when it played out the way I told them it was going to play out, I got a lot of credibility. That's
a really good actually segue into then basically the prosecutor's opening. Was there anything that the prosecutor said in their opening that, you know, maybe caught you off guard, or that you felt that you needed to specifically attack or address in your opening?
Well, yes. So a couple things. She kept on saying that, you know, he put everybody's life in danger by driving while intoxicated on the road. And it was just so laughable because he, you know, drove 3 blocks while flagging down a police car. And so, you know, I made sure to address that in my opening. And she also kept repeating the things in the police report that were just so clearly debunked by the video evidence. And so I made it a point to say, like, look, the way she's saying that this is going to play out, it's not going to play out that way. You're going to hear the officers testify that, and that's not what the evidence is going to show. And I kept it a little bit more vague about what they were going to be impeached with, but I did make it clear that, you know, what they were going to say was going to get debunked.
Did you get the sense that maybe the prosecutor didn't watch the body-worn camera?
So Yes, because when I tried to negotiate with her. Oh, quick side note about this prosecutor. This was not our first rodeo together. I had a very contentious trial with her in the past on a municipal code violation case where she was being extremely unreasonable, and we didn't like each other from the beginning, and so we were going in with a bit of a sword past.
I love this.
Yeah. So, anyways, I sat down with her and I was trying to show her parts of the body worn where, I'll get this into more detail as we do the trial breakdown, but it shows her officer challenging my client to a fight unprovoked. And she just goes, "Yeah, well, I don't love that, but it's still DUI in 148."
Smooth. Okay, and I have to ask because the defense brain of mine is just going bonkers right now because specifically with me, like anytime that I'm talking to someone who's charged with DUI, we in the DUI realm, we always let them know that for the most part there's two main defenses that have success in courtrooms, and that's one, the defense of rising, where we can potentially argue that the BAC was below the legal limit, which in this case you can obviously make that argument since they're not even alleging that he was at an unlawful limit, or two, no drive. And that's actually where my curiosity is going in this case, because as you indicated, your client was the reporting party, and so I'm a little unclear as to how the prosecution then collected the evidence to establish that your client was driving. Can you fill me in a little bit on that? Like, was there a witness? Was it the cops? Like, how would they get that element satisfied?
Yeah. So the way that they knew he was driving, so when he called the police at this party. So he's at this party. He sees this girl being harassed and groped, and is very alarmed. She tells him that she's only 17. He tells this guy to back off, and he, basically says, "That's my girl, leave us alone." So he calls the police. They're not responding. They're taking forever to respond. So he steps outside of the house party, sees the police car that's maybe 2 to 3 blocks down the road, gets into his car. He only lives about 10 houses away. It's about a block away from where this house party was. So he gets into his car, drives to the police car to flag them down. So they observed him driving.
Got it. Okay, that makes more sense. And wow, I'll reserve my comments, but yeah, that just seems like that sucks. Like you do all of these, you make all of this efforts to try to be a good Samaritan and a good citizen, and look at where it got you. Like, I hate to see that happen. But fortunately,
it's going to get worse. It's going to get worse because we still have the prosecution's version, the only one out in the ether. It's going to get a lot worse for them.
Well, that's why I'm just so thankful that we have people like you and I, and just the defense bar as a whole, because it's like people should not find themselves in these situations. Good for your clients for not crumbling to the pressure of the system and just trying to get a quick and easy plea deal, but instead, exercising his rights and fighting this case all the way through. So kudos to him and kudos to you. So we addressed the openings a little bit. Seemed pretty, the prosecution had their version of events that would mirrors, obviously, the biased, what I'm going to assume, biased police report that was filed. And then we have your version, which is...
The police reports are biased? I thought they were just fair, neutral, arbitrary.
Objective? Nah, buddy. That was one of the biggest things that I like to tell my interns when I think that they think that. Oftentimes when we get law students who are new to the system. And I was guilty of this too. When you read a police report, you think that's what the officer is doing until you realize, no, like their entire purpose of writing any and every police report is for that situation to end in a conviction. And so it is not biased.
Especially on 148.
Yeah, exactly. Because that is 100%. That's a great point, Luke, because that's 100% a liability issue. And I can't stand when there's just single count 148s, because all that is to me is a red flag that the police are trying to cover up their conduct. Because for those of you who may not know this, within the criminal justice system, if an individual is charged with resisting arrest or injuring an officer, one of the caveats is that the officer was in the lawful performance of their duty. And so even if there was arguments for an unlawful detention or potential injury as a result of the police officer, if you're convicted of that type of offense, then you are barred from any civil liability, because then a jury or a plea deal would say that the officer was acting lawfully. And we don't want that. We want to hold law officers accountable when they're mistaken and when they act in error. And we don't want to give them easy outs by ways of plea deals. So take us into the prosecutor's case in chief. What were the type of witnesses that they tried to call? How were they really trying to lay out the elements to the jury of them proving guilt beyond reasonable doubt?
Yeah, so they called the two officers who were in the patrol vehicle at the time. They called a officer who said he later responded to the party and didn't find this underage girl being harassed. There were, I think there were a couple other witnesses, but those were really the focus, the most important three witnesses, I would say. This prosecutor was not known for being brief, so I think she may have also called other people who had reported, but that were just worthless.
But she really went just kind of law enforcement heavy. There wasn't really any background information from like people at the party to like talk about how your client was acting, how much he might have been drinking.
Oh, there's a reason for that. We'll get into that with one of their cop witnesses.
Okay,
the one who went to the party.
Yeah, elaborate on that. So why don't you give us a breakdown as to what that officer was basically saying he collected and how they were trying to then tie that to your client and the charges that he was facing?
So I assume the reason why she called this guy was to suggest that my client was just some like drunk lunatic who was imagining this. That's my guess, because nobody disputed the 911 call. Nobody disputed that he was the reporting party. The police wrote that in the report. There was a 911 call. Nobody disputed that. So he gets up there, this officer who responded to this party, and the direct's very, very brief. And they just ask him, did you go to this house? Did you find an underage girl being harassed? He says no. It was maybe 5-minute direct. So I get up there and I ask him, I said, you responded to this incident an hour after you got the call? And I actually didn't know how long it had been. So I was bluffing a little bit. And he goes, oh, I don't remember. I go, oh, so it could have been 2 hours. He says, yeah, it could have been 2 hours. I go, okay. And you go to this party, and this was more information I gathered from my client, where he told me how many people were at the party, like what the layout of the house was. I go, so there were 50 people at this party? He goes, yes. I ask him, there was a lot of rooms in this house, right? Yes. You didn't check any of the rooms? No, I didn't check any of the rooms. But you taught, and you were at this house. Again, I was bluffing. I asked him for about 5 minutes. He agreed to that, about 5 minutes. I asked him, it could be less. He goes, yeah, it could have been. Go, and you talked to all 50 people in those 5 minutes? He goes, no, I talked to one. So I go, okay. So you responded to this party up to 2 hours after the 911 call. You don't check any of the rooms. You talked to one person out of 50 people there, but you're confident that there was no underage girl there being harassed. Great work, officer. Glad we have you out there in the field. And then I get objected to, and it gets sustained. And then this is where I was being a little cheekier, and I was kind of dared to do this. But one of our arguments was like, look, these cops got so distracted with focusing on my guy, they didn't even pay attention to this like poor girl who is intoxicated, getting harassed. So I asked him, I said, you didn't check any missing persons reports the next day? You didn't convene a search party to find a dead body? And he goes, no. But so I had a field day with him. But it just showed that they were. I think what that testimony showed is that they were trying to show a very focused, biased version of what happened. No girl found. When you dig just a little bit deeper, and you find out that they show up 2 hours later and don't interview anybody.
Did the initial 911 call that your client made, did that get played? Was there any kind of focal point about the trial that centered around that?
I didn't play it because I don't think he sounds drunk in it, but I can see how somebody could perceive it that way because he just sounds really stressed in it. So it was undisputed that he called. So I just, had that fact in there without playing it because I didn't want it to be interpreted as, oh, he sounds maybe a little slurred or belligerent.
Now, and earlier you had said something about the facts that I also noted and wanted to follow up on. You were saying that basically they had only charged your client with the A count because they didn't have the alcohol results.
Yes.
Could you explain that a little bit more? Like they had absolutely none? Because if that's the case, I have follow-up questions. Or were they able to get some, but it just didn't past the threshold of the legal limit.
They had nothing. And I forgot to mention, they also alleged a chemical refusal allegation on this case.
Okay. So, yeah, explain that to me. I mean, how did the prosecutor then essentially try to prove that your client was under the influence of alcohol if they didn't have any scientific evidence to establish that he was under the influence of alcohol?
Basically, it was a few things. They said that he was driving erratically when he was trying to alert and obviously we had explanations for all this, but he was driving erratically when trying to alert the police officers that he smelled like alcohol, that his speech was sort of rapid and slurred, and he had red eyes, and that he was refusing to do a chemical test. So they basically said, look, you add that all together, he's impaired for the purposes of driving.
But couldn't he be impaired by something else?
Well, that's what our job is for. And apparently she had never thought about that.
Okay, I love that. I'm just like, that's a very crucial element that you have to establish that if you're charging someone with being under the influence of alcohol. And so it sounds like really then they just spent a lot of time with the officers who had contact with your client and had them testify to what they perceived as the objective signs?
Yes, exactly.
Okay, then you mean you alluded to the fact that your client quote unquote refused a chemical test. What about any field sobriety tests? Did they try to have him do those? Was client willing to perform any of those?
So here's the funny thing about the chemical test. They said it was a refusal. In every video that even she played, he was agreeing to do the chemical test.
Gotta love that.
And she misinterpreted some of the language. Like at one point, their argument was that because he was so belligerent that they could just tell he was going to be a refusal, that they just felt like he wasn't going to cooperate, even though every time he said, yes, I will do the chemical test. They asked him if he would do field sobriety tests. And he says, I'll do whatever you want me to do. You want me to do burpees? I'll do burpees.
I love that.
So he was willing. They just said that he was too obnoxious and aggressive, so they deemed him to be a refusal on everything.
And so then during the prosecutor's case in chief, she obviously played some elements of the body-worn camera.
Yeah, she played the first interactions with the police officer and with the client. She played what she put most of her energy on and most of her focus on was client's behavior at the police station when he was being booked, where he was kind of cussing out the officers and yelling at them, understandably so, because he was so frustrated that after trying to alert the police about this, it ended with him being, in my opinion, assaulted by the police officers and then hit with a DUI and a 148.
Now, one of the things you had also mentioned too, fortunately for you, it sounded like the judge excluded some of the harmful statements that your client may have made in his moments of frustration with the police. What about that portion that you tried to show the prosecutor where you felt the officer unprovoked challenged your client? Was that able to come in, and was that seen by the jury?
Oh, I got it. I got that in cross. Yeah, so just to explain what the video showed, what it showed was after the officer activated about right when all the cars got parked, they exit the vehicle. You hear my client tell the officer, "You're a rookie. You're like a bitch ass cop." Cussing at him, and the officer in response says, "You want to come at me, bro? Let's go," and then grabs my client. And you can see that between the two officers' videos and the officer admitted this during cross that he made the first physical contact with my client after saying, "You want to come at me, bro? Let's go."
Nice. Gotta love that. Okay, so by the time the prosecution got done with their case in chief, sounds like they played some body-worn camera, really leaned into the whole training and experience of this officers. When the prosecution got done with their case in chief, at that point, what did you feel like during your cross-examinations that you really had to focus on to negate what the prosecutor was trying to do in their case in chief?
I focused on a couple things. One, that a lot of it was impeaching the officer's version of events. So I obviously focused on. I kept on asking the officer, you said this. You said, "You want to come in, bro? Let's go." You challenged. You made the first physical contact. The fun thing about 148s is when the police are in the wrong, it almost doesn't even matter what the other charge is. Like, you can really get the jury outraged on all the counts based on the 148. But I asked the officer about this, and he claimed that saying "Want to come at me, bro? Let's go" was actually a de-escalation technique.
Wonder where they train that at.
Well, so it's funny they asked. Fortunately for me, I was in the middle of my cross and we had a break for the day. So that night, I printed out the LAPD de-escalation guide, and I brought it with me in a binder the next day. And I started reading off to the officer all the de-escalation techniques, got him to agree that those were the de-escalation techniques. And there are things like empathy, asking open-ended questions, speaking in a calm voice, things like that. So I list them all to him, and he agrees that those are them. I ask him, is there any one that I'm missing? He says no. We go, okay, officer. So when you said, "Want to come at me, bro, let's go," was that empathy? No. Was it, maybe it was asking an open-ended question? No, it wasn't that. Were you speaking in a calm voice when you yelled that? No. Okay, so I list them all. He agrees that they're none of those. I said, so which of those was it? He goes, well, it's just totality of the circumstances. That would just be his response number. It's totality of the circumstances. I go, okay. So I'm holding this LAPD de-escalation guide. Can you show me where in this guide it explains the type of technique that you're using? He goes, it won't be there, but I got it in my training. The best part, though, is he then claimed in his redirect that when my client referred to him as bro, that was a challenge to fight.
Love the double standard there.
Oh, and he said it was a technique that he regularly uses.
That's terrifying.
He says, "Want to come at me, bro? Let's go." That he does that regularly. Because I got him locked in. I said, you didn't treat my client differently because of his race, because of how he looked, his gender, anything like that. You would treat him the same way you would treat anybody. And so the language you used to him is how you'd say to everybody. And then so I kind of got him locked in, and then he agreed that yes, this is something I would normally say.
That's terrifying. And that's why people say that tough guys just want to have a badge and a gun so that they can live out their fantasies of being bullies. Did you find yourself having to play these extra portions or clips of the body-worn camera that the prosecutor was really just trying to cherry pick her most beneficial parts, or were a lot of the parts that you wanted to show also shown when the prosecutor played parts of the body-worn camera?
Yeah, it would be, depending on what part it was one of two things. Either she wouldn't play it at all, or she would play it but focus on everything but the part that was damaging to her. One other thing that I think was important was it wasn't until they actually got into the altercation outside of the car, I got both the officers to say this in their cross-examination, that they ever had any suspicion that client was DUI. So they interacted with him 3 different times before they all get out of the car, and while he was driving, they never suspected that he was DUI. So that's an important fact worth noting.
Where did the suspicion of DUI finally come up then?
Well, because of the 148 is my opinion, but they said they smelled the alcohol on him. And so that was what initiated the DUI investigation.
So does that come like towards the end of the body-worn camera clips where he's at the station and being arrested?
So what happens is he sees this patrol car and he drives up to it. He alerts them and says, "Officers, this I called 911, nobody's responded, but he explains what happened." And they say, "Thanks for letting us know." They start driving the opposite way. So he gets frustrated, and this gets all established in cross-examination and through my client's testimony. He then drives, he sees it going the wrong way. He gets worried. He thinks that maybe they're just not understanding where he was saying to go, that they are confused where to go. So he drives, and he drives parallel to them, and but facing oncoming traffic, but there's no other cars. And they say, "Dude, you need to get out of the road." He goes, "But you're going the wrong way." And they go, "Okay, but you're in the middle of the road. You need to get out." And they continue to drive the other way. So this is when he pulls up to them the 3rd time and starts cussing at them. The cars go and park, and then everybody gets out of the car. So the first 2 times, really even 3 times that they interacted with him, no suspicion of DUI, because otherwise they might have asked him to pull over and start a DUI investigation. It wasn't until they're all out of the car and the officer challenged my client to a fight that he decided that he was DUI.
What I love about that too is earlier you had mentioned about how the prosecutor, was making the argument to the jury about public safety and ensuring this guy isn't DUI on the road. But it sounds like the majority of the reason why he was on the road driving for as long as he was is because the officers didn't suspect him of being DUI and they didn't immediately say, okay, stop, we have to investigate, we have to get you off the road. They just kept going the other way, and that's what led to your client driving more and more. So
isn't that curious?
Yeah, it sounds like that the safety to the community would have been better handled if the police actually just listened to the concerned citizen. So by the time you got done with your cross, what were some of the victories that you felt that you were able to have elicited? Earlier we were talking about how they weren't able to, or they shouldn't have really been able to establish what the substance was. Was that really a big focal point of your cross, or was that something that came later in your case in chief?
We never really disputed that they smelled alcohol. I mean, I made it a point that he had no idea what type of alcohol it is. They always use the same term, strong odor of unknown alcoholic beverage.
Yeah.
Which is funny because alcohol itself doesn't have a smell. It's the additives of alcohol. That's why beer has a different smell than wine. And non-alcoholic beer is going to smell the same as alcoholic beer. So I stressed him that he had no idea what he was smelling. Could have been a beer. Maybe it could have been a shot of whiskey, but it also could have been a beer. He had no idea. He had no idea how much, client had consumed, had no idea when that alcohol was consumed. So basically had no idea what level of impairment he was actually at. And even though this was not a numbers case, everybody just sort of knows that the legal limit's 0.08. So I kind of made that a point in the cross too. Like, look, the limit normally is 0.08, right? You have no idea what he was at that time. So arguably maybe not the most relevant question to ask, but I know that it meant something to the jury.
Yeah, absolutely. Well, and it sounds like also the biggest thing that's incorporated in an A count that's not a part of the B count is the impaired driving. What did the prosecutor try to elicit from the cops to highlight that there was an impaired driving, and what were the things that you did to combat that?
So they said that he was driving erratically when he was trying to alert them down, that he was tailgating them, that he had pulled up to drive facing oncoming traffic. I just said, look, this is a guy. I mean, I was able to get this out through clients direct, even aspects of the cross-examination of the officers. And in closing that, we saw that this guy was stressed out. He was freaked out about the police not responding to his call. He was very concerned about this young girl. And he was trying to do what he could to alert them. And they cannot prove that that was because of the alcohol that was causing any of that erratic driving. In fact, every fact establishes that it was just him being concerned and alarmed about what was happening.
Well, it sounds like you were able to make some excellent points on cross, and that the prosecution didn't
Yeah, it usually doesn't go this well. For your listeners, it usually doesn't go this well.
Yeah.
But this time it did.
Yeah. Well, it also sounds like your prosecutor had arguably very limited facts to go off of. I'm assuming, by the time you got done with your cross-examination, you were feeling somewhat confident of making your motion for a directed verdict. Did you ultimately make that in this case, and what was the judge's response?
I definitely made it. This judge, I have a lot of respect for him, but 1118.1s are not where he's gonna hang his hat. So it was denied, but it was still clear where he thought the case should go. I just don't think that he thought it raised to the level of a directed verdict.
And it sounds like you had definitely had the facts at least on the table to make that potential argument, especially with the, no alcoholic measurement, no field sobriety test, really just going off of an officer's observations.
One other thing that I want to mention about the cross. So, one of their theories of the 148 was that client pulled his car out in front of the patrol vehicle, blocking its movement. That was absolutely not true. I can't remember if I read that in the police report for the first time or if I heard it in direct for the first time. But if you looked at the body worn, when they all got out of the cars, which was the time that they said that he was blocking them, was right before it went park and they all got out, the cars were perfectly parallel to one another. So in cross, I established that this was the point in time where the car would have been blocking it. At this moment, like I stopped part of the video and say, okay, you're now getting in the car because he's blocking you from moving forward. That's right. Nobody moves the cars later, right? Yes. They all get out. And I pause it and I say, officer, those two cars are parallel, aren't they? What do you think his response was? No, they're not. So, he just looks completely, looks like a liar. He looks like a total liar. The jury is looking at this video. These cars are perfectly parallel to one another. And he is standing by the proposition that no, actually, your eyes are playing a trick on you. That car was blocking my car from moving forward.
And that's why I love body-worn camera, why it's so important, because it is a true representation of what happens. You can't add bias to the camera. You can't put a certain type of spin or narrative on the camera. And it comes in so handy a lot of the times. To even if it's not a direct impeachment or contradiction, it just provides that extra context that I think the officers add fluff to their police reports that is able to take that sting away out. So kudos for you for highlighting that, for pinpointing that, and for obviously it seems like taking the credibility away from that officer. After the 1118 got done, that's then when you have an opportunity to put on your case in chief. You know, as a defense attorney, it's more of a rarity for us to do that. But was that something that was done in this case?
Yeah, client wanted to testify from the beginning. I should mention that there were a few times in this trial that he did get cold feet about having this case go on to verdict. At one point, sometimes we think our case isn't as good as it is when the officer first testifies and we've just heard direct before a cross. So he started getting nervous. But he was still, if it was going forward, by the time we got to that, he was pretty adamant that he wanted to testify. And I told him that I agreed that he should. I thought he had a story to tell. I thought that his story made way more sense than what the police were saying. It was completely consistent with the video evidence we had. And it was able to explain away some of the less than ideal facts for us, like why he was cussing at the officers. We were actually able to explain, part of the 148 too was they had two different theories for the 148. One was the car being pulled in front of the patrol car, but the other was him physically pulling away when they were trying to handcuff him. I was able to introduce into evidence a picture of his arm that shows that his arm has serious damage and that it was kind of an involuntarily jerking away. They talked about him having a red face. We hear a flushed face or a red face. I noticed after the first day of trial that his face was beet red. And I certainly didn't think he was intoxicated. And I asked him, I said, "Hey, your face is really red. Why is that?" He goes, "Oh, it gets like this when I get really stressed." And just being in trial, he was really stressed. So I said, "Okay, I took him to my office. I took a picture of his face. And that ended up being admitted into that's one of defense exhibits.
Oh, I love that. Kudos for you. Way to take advantage of that kind of late observation and something that could obviously come back and tie to in an excellent way for the trial. The other thing that I wanted to say was I was going to make a joke about how could they charge him for, delaying or obstructing their investigation when it sounds like they're driving the opposite way from what he wants them to investigate. So where's the delay or the obstruction? So that was also
Yeah, it was also just silly that the idea that he'd be trying to delay the investigation, that he was so insistent that he wanted them to get to. I mean, their theory just didn't make sense.
So it sounds like your client was able to hold up pretty well on your direct. You were able to elicit the story in a way that you wanted to, that was true and authentic to your story's version of events. Obviously, the most crucial part of your client taking the stand is obviously the subjecting themselves to cross-examination. How do you think the prosecutor did in the cross-examination? And more importantly, how do you feel that your client held up during that cross-examination?
Sure. So I'll say a couple more things about direct first. I thought he testified really well. I could tell the jury liked him. He explained that he was at his house because he lived right by this house party. He had one IPA just a few minutes before this whole incident went down, that he walked over to this house party, or he drove over to the house party, admitted that he drove. It was 10 houses away. It was just quicker to just drive right there, wanted to check out the music, and then saw this all unfold. So we explained the drinking pattern. We admitted that there was alcohol. He said, "Look, this, it's non-common for on a Saturday night for me to have one or two IPAs. No, it did not affect my ability to drive at all." So we were able to explain that away. We were able to explain, he testified that these officers challenged him to a fight, that he was willing to do the chemical test, that the only reason he pulled away from the officers was because of his damaged wrist. And you hear him in the video saying, "Oh my God, my wrist." So everything he said was completely 100% consistent. And it wasn't like his story started adapting to as he saw the trial. This was the story he told me from the first day I met him. I still prepped him. I had a much more experienced attorney in my office, cross-examine him. But and he made some good points in his cross, my boss at the time, that made me a little bit nervous. But she missed all of those points. It was all ad hominem attacks. At one point she thought she caught him in a lie. And because he said, I never refused the chemical test. There was no point where I refused to do the chemical test. I think he said something like, if I ever did, it might have been because I was so frustrated that they kept saying I will do it and they wouldn't give it to me. He goes, but I don't think I ever refused it. So she finds the video and she plays it, and they're telling him, you're refusing the test. And he goes, did I say refused, bro? Like, he's asking them, like, did I ever say I refused? She misheard it. She thought he was saying, didn't I say I refused? So she plays it and she goes, right there, you said, didn't I say I refused? And he goes, ma'am, that's not what I said. Roll the tape, play it again. I said, did I say I ever refused? I was asking them the question. Did I ever tell them that? And she falls in the trap. She rewinds it, and everybody in the courtroom is listening so carefully. I think the volume got amplified a little bit, and you hear it. It's clear as day. Did I ever say I refuse? And I looked over at the jury, and you could see people kind of looking at each other and whispering to each other, and it was pretty clear everybody was saying what I was saying too. So,
wow, I love your client. What a moment of confidence, and again, I think like so many people, like win, lose, or draw, I think like it's those opportunities that really motivate people to take their case to jury trial, to have their day in court, to have their voices heard. And I have to assume that moment was so validating for your client to, be accused and try to be discredited and just be able to be like, that is not how it happened. And so much so, like, replay what you just did. So I absolutely love that. Kudos to your client. Like that.
I could tell that even if the case hadn't gone our way, he was, all of his other cases he had always pled out. I could tell that it felt good to watch, them have to prove it, and to watch the cops take some heat during cross-examination.
Hell
yeah. He
never
had that before.
Love that. Okay, so you're in your case in chief. You call your client. He gets crossed. Is that the only evidence you end up putting on?
Only witness I called was him.
Okay, so then we go to closing. Now it seems like at closing, we seem to be very far away from where we started the trial. Does the prosecutor adjust for those variables and circumstances that have occurred throughout the trial, or do they go forward with, you heard from the officers on direct, so you should find the client guilty?
Like most prosecutors, she, adapted to the ever-changing circumstances. No, she repeated everything she said in opening. Like verbatim, nothing adjusted. She kept on she had a weird theme and theory. She kept on saying, this isn't a classroom. This isn't academic theory. We're talking about officers who are on the street. We can't theorize about how they could best respond. One of my favorite moments of her closing, and I can't remember if it was her A argument or her rebuttal, but she gets up there. No, it was definitely her rebuttal because, obviously I had a field day with how they behaved. She gets up there and she says, and I actually jolted out of my chair when she did this. She said, officers have tough jobs. They can't always use kind language. They can't always say please and thank you. Sometimes they have to say, and this is an exact quote of what she said, sometimes they have to say, get on the fucking ground, put your hands in the fucking air, drop your fucking weapon. And she shouts that. I just jolted out of my chair. Where did that come from?
Because that didn't even happen in this case, did it?
No. There was no weapon. It was the officers starting the fight. It was she missed the whole point of the whole trial. And, I made a point of this. My first line in my closing was, were, prosecutor and I even in the same courtroom this last week?
Wow.
Because it didn't seem like it based off what we just saw. She looked you in the eyes, she stood up, she looked you in the eyes, and she told you things that she knows are not true. Because in her closing, she also said, this car pulled out in front of the other car and blocked it from leaving, that he refused to do the chemical test. Even though everybody saw that she was wrong about what the chemical refusal, she still repeated the same line over. It was like a pre-programmed robot that was, less sophisticated than ChatGPT because it couldn't even adapt to what happened. And so,
walk us through your closing then. I mean, obviously we know some of the comments and pieces of evidence that you were highlighting, but what I'm really interested in is, how did you use what you've broken down so far in this episode. How did you then use that to weave in and out of the elements to establish that, not all of them were met, beyond a reasonable doubt, and because of that, the only just verdict would be not guilty? What were the parts of the elements that you really focused on?
Yeah, well, I'll just, before I get to that, one of the other lines I had after I made the comment about her is I said, look, we hear in the media a lot about, the bad cops. It's just a few bad apples. And I said, well, these are the bad apples right here. These officers do not have the decency, the integrity, or the honor to carry a badge and a gun. So when I broke down which was obviously crucial for the 148, for the DUI, I mean, the calculum says that, and the statute says that the alcohol itself has to so impair your ability to drive that you cannot operate it with the same caution and care that a sober person could. And I just explained to them, I'm like, look, they have no idea how much alcohol consumed. We saw that he acted erratic, but all of that is explainable by the fact that he was getting annoyed and frustrated with the police officers when they wouldn't respond to what he was calling them about this young underage girl, that anybody in the same situation would also behave a bit erratically, at least a bit. I mean, I was like, look, this guy did something that I probably would have been too afraid to do, to try to keep on following the cops and alert them and get their attention. So I thought that it was pretty easy to explain that to any extent we saw bad driving. It was, I love our good old calculum 224. You have two reasonable interpretations of the evidence, and if one points to innocence. And I said, look, it's not even that we have two reasonable interpretations here. I go, the most reasonable interpretation is the one that points to innocence here. That's not even the standard, but that's what we have here. So that was how I tackled the DUI. The chemical refusal too. I was like, look, we saw the video evidence. She got up here, she told you that it said something it didn't. And I even told them, I go, remember when she thought she caught him in a lie and she had to play the video, and we all listened a little carefully, and we heard that it was exactly what he said it said. And if you doubt that, I encourage you, go to the jury room and play it over. You'll have a chance to. So that was the DUI. The 148, again, there was two different bases where obviously they have to be unanimous on which it is, or they could say it's both, but whether there was the allegation that he pulled his car in front of them and the allegation that he physically resisted. I mean, pulling the car in front of them, that was just easy. I mean, I one of my PowerPoint slides was just a giant picture of the cars parallel to one another. And I said, look, we know what they said isn't true. I mean, this isn't even a close call. On the physically resisting part, part of 148 is you can resist against unreasonable force. And I laid this out as like the officer was acting clearly unreasonably. He challenged my guy to a fight. I had a PowerPoint slide that said, in quotes, "Want to come at me, bro? Let's go." And then I attributed it to the officer. And then I said, an LAPD de-escalation technique, not at all threatening, not at all aggressive, as like what the prosecution's theory was. And the next slide was, "What's up, bro?" And then I attributed the quote to anybody who's not a cop, obviously threatening, obviously aggressive, a challenge to fight. And I got some laughs when I had those two up. So I established it as these cops, they were looking for trouble. They challenged him to a fight. And they made the first physical contact. That client tried to pull away. And that even if you thought that their force was reasonable, the reason he pulled away was more involuntary than anything. It was because he had a wrist damage. And so, yeah, that was sort of how I tackled the elements on each of the charges.
Well done, Luke. Well done. That sounds like, definitely a lot of arsenal of, facts and evidence that you were able to utilize in your closing, which is definitely not always the case. And so power to you. Ultimately, how long did the jury deliberate for?
So this is the fun part. They're out for about an hour. They said they have a question. How do they have a question? This is, I thought this was a 30-minute not guilty. The question is, and by the way, the prosecutor thought the opposite. She thought that she really thought she was going to win this case, which was maybe even the most shocking part of it all.
Slam dunk, baby.
So they said their first question was, "What do we do if we can't reach a verdict?" And I thought, oh my God, no, there's no way. So the judge brings out the foreperson and asks not which way they were leaning, but what was the breakdown. And she said 11-1 on both counts. I immediately knew it was 11 not guilty, 1 guilty. And I'm thinking to myself, who's the motherfucker on this jury?
Somebody lied during the voir dire.
So But what's funny is
lied his ass off during voir dire.
Guilty, not one, not guilty. She's like, Your Honor, they have to continue deliberating. And I'm like, yes, Your Honor, I actually agree with her. They should continue deliberating. So they get sent back, and then 4 hours later, this story is going to eventually have a happy ending, but it takes a bump in the road. 4 hours later, they come back again and said, we still can't reach a verdict. What do we do? So they bring all of them out, and a mistrial was actually declared, and it was revealed it was 11 not guilty, 1 guilty. So client was thrilled. He was like, this is great. Like, this is eventually going to go away. And I knew it was going to go away after this too. But it was still frustrating that one person could have sat through that all and voted guilty. It really shook my confidence.
Yep.
And I mean, I've had cases that I've gotten, flat out walked the person, not guilty, that were way weaker than this. So it shook my confidence a little bit. We talked to the jurors after, and they all said, look, this guy wouldn't even deliberate with us. We would say, like, well, those 2 cars, they're parallel, right? He goes, yeah, I guess they are. They're like, they're not guilty. He goes, I don't know. I just don't think he's guilty. That was his response to everything. I just don't think he's guilty. And they were frustrated with him. They were basically yelling at the prosecutor at the end. I think 11 of the 12 jurors stayed behind to talk, and that guy bolted. And they yelled at her. They said, why did you lie to us? You kept telling us. They were using my lines for my closing. Why'd you tell us things that you knew were not true? Why did you say that, the car pulled in front? Why did you say that he was refusing? I mean, they were mad at her. They were really upset. So, I immediately asked for a 1385 dismissal. This judge was, again, obviously going to grant it, but he's very much a politician, so he wanted briefing on both sides. She's like, Your Honor, 1 juror voted guilty. This shouldn't get dismissed. I'm like, oh, geez. So I see her the next day, and we countered it for 2 weeks for a motion to dismiss. I see her the next day, and I say, look, Miss Prosecutor, we all know what the judge is going to do. I'm like, I think it would show some decency, show some integrity, just get ahead of it and dismiss it. And she looks at me and she goes, I'm not worried about optics. And then I kind of grinned with a smug look on my face and said, oh, I believe you. And so what ended up happening was, again, the judge was always going to dismiss it. This other prosecutor who I actually really, really liked and respected, and who has actually since left that office, she had the case advanced and dismissed it. So case fully dismissed.
Woo, let's go.
Well
done.
I think that her supervisors, I actually think my understanding was the supervisors kind of told her to dismiss it. This one prosecutor was the one who wanted to keep it, wanted to retry it, and they said, no, it has to be dismissed. She refused to do it herself. So this other city attorney, who I really did respect, who I think is actually a very honorable prosecutor, she did it herself, advanced the case, made it go away.
Well, that's a bummer on the 11-1, but at the end of the day, a dismissal is just as good as an acquittal. And, I see, I know the frustration you're feeling. I've definitely been there, and had the exact same result. I can't imagine a case that ever hung 11-1 in favor of not guilty wouldn't end in a dismissal. But it takes away some of it, and I don't know, maybe it's my bias speaking, but for me, like an 11-1 for not guilty is totally different from an 11-1 for guilt, right? Like at the end of the day, it's because you're supposed to start at not guilty, right? And so for someone to be like, look, that's where I started, and there wasn't enough evidence to persuade me, despite it persuading 11 other people, well, that's the part of the system that you have to love and cherish, because that's it's doing its job. However, in the inverse, it can't be true. Like if you have 11 other people saying like, no, there's no way that this evidence is proof beyond a reasonable doubt, and you just have that one juror who is clearly fighting against the others, I just don't see them the same. Again, maybe that's my bias speaking, but look, at the end of the day, Luke, what a fantastic result. Way to fight for your client through the end, even despite the hang, and ultimately getting a just outcome. So thank you so much.
Client was thrilled. I texted him today to tell him I was going to be on a podcast to talk about his case. We still stay in touch. His great client, great trial, slightly frustrating result in the very beginning, but still got the dismissal in the end. And so it'll definitely go down. And
still got his Freedom Friday. So that's fantastic. Luca, the question that we always ask our guests at the end of this show is, what's the significance of taking matters to the box mean to you?
I think a way to describe that is to actually say what one of the jurors said to me after this trial was over. She looked at me and she said, "Is this officer ever going to be held accountable for what he did?" And the answer is not really. Not he's going to continue to get on the stand. He's going to continue to lie. I actually had transcripts in this case ordered so he can be impeached in other cases, but there's no real accountability, right? He's not going to lose his job. He's not going to lose his pension. He's going to terrorize more people, abuse more people. The only way that we can sometimes hold the system accountable, hold police officers accountable, hold civilians who lie accountable is by taking it to the box, to have members of the community who aren't really seeing what we're seeing every day have a moment, a week, 2 weeks to see it happen, to see it unfold, and to look the government in the eye and say, what you did is wrong. Because sometimes these prosecutors, that's what they're supposed to be doing. They're the ones who are supposed to look at officers and say, I can't bring this case. What you did was wrong. And when they don't do that, sometimes it takes the members of the community, the members of the jury, the people in the box to look the government in the eye and to tell them no. To tell them that what you did is wrong.
Ooh, I love that. That gave me chills. I might have to steal that in the closing line. I often say that, in the closing, I say, throughout this trial, like it's been my job to hold the government to their burden. And as you go and deliberate, I'm now passing that job on to you. But, you're exactly right with that. Even a just verdict doesn't mean accountability, for that specific officer, for that specific police department. But what we do have control over is holding them accountable throughout the trial, and a jury does have the authority to hold them accountable or the lack thereof by rendering just verdicts. So, Luke, thank you so much for joining us on this fantastic Freedom Friday. What an amazing result for your client, for your community, and for yourself. And we're wishing you all the best in all your future endeavors. We hope to have you back on as a guest sometime with another Not Guilty. So thanks again. Well, members of the jury, that's our show, and I rest my case. Be sure to come back next episode as we take another matter to the box. If you're a fan of the show, go ahead and subscribe. You can also find us on social media at Members of the Jury. If you want to be a guest or have any feedback, be sure to email us at lhursty@membersofthejurypod.com. The information in this podcast is provided as general reference work as a public service. The audience is advised to check for changes to current laws and to consult with a qualified attorney on any legal issue. The use of this material does not create an attorney-client privilege in any fashion with the podcast, the host, or the guest. This information is for educational purposes only, and no one affiliated with the podcast may be held liable for any decision made based on this information.